She's gone from being a vilified royal mistress to the woman who will now shape the future of the monarchy, Camilla Parker-Bowles.
Records show that a confidential six-figure legal retainer was recently transferred from a private royal account to a premier London litigation firm. The precise objective contest the freehold title of a high-value Wiltshire estate parcel adjacent to Ray Mill House. This was not a routine domestic dispute or personal fallout between senior royals. While mainstream media reported the friction as simple family tension, internal audit documents confirm a structured effort to reclassify sovereign property rights. At stake is the operational integrity of the Crown estate and the enforceability of irrevocable trust protocols codified under Prince Philip's 1990s Estate Restructuring Directive statutory provisions designed to prevent public royal assets from being diverted into private inheritance lines. Attempting to convert a lifetime residency right into an alienable private asset presents a precedent that threatens the constitutional foundation of royal financial stewardship. Before we examine the unredacted court filings, let's trace how a single routine audit exposed this institutional showdown. The crisis did not erupt from a personal altercation or a sensationalized tabloid leak. It began in utter deliberate silence within the secluded offices of the Royal Financial Audit Committee at St. James's Palace. It was late autumn, and the periodic budget settlement documentation of the sovereign grant was being subjected to rigorous internal review ahead of the upcoming annual hearing before the Parliamentary Public Accounts Committee. Against the backdrop of a United Kingdom economy heavily burdened by inflation, escalating living costs, and unprecedented public scrutiny over state expenditures, every single figure embedded within the royal financial governance system had to pass through the most uncompromising tiers of independent auditing. Each line item required not merely routine accounting justification, but complete compliance with constitutional standards governing the transparency and integrity of public assets. Prince Edward, serving as advisory supervisor over internal trust funds and royal heritage assets, was systematically auditing fourth-quarter financial transactions. Far from the public perception of a purely administrative formality, managing these trusts demanded a profound mastery of contract law, constitutional financial regulations, and centuries of intricate land tenure structures. On page 142 of an independent audit report produced by a prominent international accounting firm, Prince Edward identified an anomalous line entry. A wire transfer totaling precisely $350,000 had been executed from a private subsidiary trust under the administrative authority of Queen Camilla. This substantial disbursement was not itemized under any recognized category for living expenses, official charitable endeavors, or routine administrative overhead. The designated recipient was the escrow account of a premier litigation law firm located on Chancery Lane in London, a high-caliber legal practice specializing in complex commercial disputes, massive inheritance litigations, and land tenure contracts for Britain's oldest landed families. Transaction logs extracted from the banking system revealed that this was no standard fee for advisory services, but an initial litigation retainer. The payment was designed to finance an administrative lawsuit at the High Court in London, aimed at reclassifying the legal status of a 45-acre parcel of land directly adjoining the Ray Mill House estate in Wiltshire. Ray Mill House was a private property purchased independently by Queen Camilla in the 1990s prior to her official marriage into the royal family. However, the adjacent 45-acre parcel belonged to the portfolio of the Royal Trust System, bound by strict constitutional protection clauses and public asset management regulations. Extracted audit files and transaction logs revealed the ultimate objective of this covert legal campaign: to convert the parcel from a fixed-term leasehold interest into absolute private freehold ownership. Had this reclassification succeeded, ownership of the land would have been completely severed from the royal estate portfolio, establishing a solid legal foundation for its lawful transfer to non-royal bloodline heirs. Years of reviewing institutional governance records gave Prince Edward the sharp intuition to recognize that this was no simple boundary adjustment or personal estate expansion. With Parliament continuously tightening rules on public assets and the sovereign grant, a property lawsuit initiated by the Queen Consort against institutional trusts would trigger a constitutional crisis of unprecedented proportions. Prince Edward refrained from using standard telecommunication channels. He immediately ordered the extraction of all original historical land records regarding the Wiltshire parcel, including archived administrative correspondence dating back to 1995, and requested an urgent closed-door meeting with the Prince of Wales. Inside a secure soundproof study at Clarence House, the examination of the historical archive proceeded under maximum security protocols. Prince Edward and a team of constitutional legal experts spent consecutive days meticulously reviewing files dating back to the comprehensive royal financial restructuring of the mid-1990s. The crucial linchpin of the entire affair lay in the legal framework established during the tenure of Prince Philip. In 1996, following severe institutional turbulence and complex high-profile divorces among the senior royals, Prince Philip spearheaded a comprehensive overhaul of royal financial governance to protect the integrity of the crown. As chairman of the Family Estate Governance Committee, Prince Philip enacted the Special Trust Protocol, erecting an impenetrable legal firewall around all real estate tangible heritage and auxiliary land parcels held by the Crown. Reviewing the original document coded T1996 Royal Estate, Prince Edward highlighted an impeccably drafted constitutional safeguard clause. It stipulated that any individual entering the royal family through marriage, even upon attaining the rank of Queen Consort, was entitled solely to temporary residential rights and usufruct privileges during their tenure. No real estate assets, auxiliary land, or linked trust funds could ever be construed as disposable private property. They could not be title transferred, mortgaged, or bequeathed to any individual outside the lawful line of dynastic succession. Prince Philip's document explicitly stated its institutional intent to completely eliminate the risk of public asset leakage through divorce, marital dissolution, or inheritance claims from non-royal lineages. This clause directly dictated the legal standing of Queen Camilla's adult children, Tom Parker Bowles and Laura. Under this framework, neither Tom Parker Bowles nor Laura possessed any legal standing authority or claim to inherit any asset owned or managed by the royal trust system, regardless of their mother's current title. However, files extracted from the Chancery Lane law firm revealed the legal basis Queen Camilla's legal team intended to exploit. In 2018, during an internal administrative transition, a private memorandum of commitment had been drafted. In this document, King Charles III, then Prince of Wales, expressed an intention to transfer permanent ownership of the 45-acre Wiltshire parcel to Camilla, to expand the Ray Mill house grounds, providing her with a distinct estate belonging entirely to her direct family. Legal representatives for Queen Camilla argued that the 2018 memorandum carried the weight of a binding civil agreement to transfer property. They maintained that retaining the land under a royal trust was an administrative anomaly that prejudiced the lawful interests of the Queen and her private family. Prince Edward's legal team quickly identified a fatal vulnerability in this argument. In 2018, King Charles III possessed no unilateral legal authority to rescind, amend, or override Prince Philip's 1996 Special Trust Protocol. Any personal commitment that conflicted with institutional trust regulations and the Sovereign Grant Act 1961 was legally void ab initio. The institutional threat was fully exposed. Advised by her private legal counsel, Queen Camilla was attempting to leverage the 2018 memorandum to force concessions from the trust management system. Should the system yield, it would establish a dangerous legal precedent, dismantling the protective architecture of Crown assets and opening the door to the piecemeal liquidation of royal heritage. The crisis moved beyond audit ledgers and began directly impacting operational administration. A risk assessment compiled by the Royal Legal Committee warned that if the case reached the High Court in London, public exposure of a property dispute between the Queen Consort and the Royal Trust would immediately dominate global news coverage. At a time when the British public was demanding absolute transparency and fiscal accountability from state institutions, a multi-million-pound real estate battle within the royal household would severely damage the Crown's standing and trigger parliamentary debates regarding a full review of the sovereign grant. To prevent further escalation, Princess Catherine stepped forward to act as an internal mediator. Raised in a middle-class family with a practical commercial background, her parents, Carol and Michael Middleton, had built a business through strict corporate governance, financial transparency, and rigorous adherence to contractual terms. This background gave Catherine a pragmatic, objective perspective on legal risk. She understood that a public relations disaster born of private asset ambitions would deal a heavy blow to the institution her children would one day inherit. Princess Catherine convened a private meeting at Kensington Palace where she proposed a balanced administrative compromise. The Royal Trust would grant Queen Camilla a lifetime leasehold and exclusive spatial use of the 45-acre Wiltshire parcel, backed by a fixed maintenance allocation from private funds. In exchange, the Queen Consort would withdraw all filings at the Chancery Lane firm, agree that permanent title remain with the Royal Trust, and forfeit any right of transfer to Tom Parker Bowles or Laura. This administrative compromise was rejected outright. Queen Camilla, supported by her sister Annabelle Elliot, an influential interior designer heavily involved in managing the family's private property projects, maintained an unyielding stance. Annabelle Elliot argued that accepting mere temporary residential rights diminished the Queen's legal status and revoked a right formally committed by King Charles III. Furthermore, the motivation behind this resistance was tied to long-term commercial interests. For over 2 decades, Annabelle Elliot had held lucrative interior design and consulting contracts worth millions of pounds across properties funded by the sovereign grant. Securing absolute freehold title to the Wiltshire parcel was viewed as a strategic move to assemble a complete private real estate portfolio, generating independent commercial revenue and a lasting legacy for her family, entirely separate from Prince William's future oversight. The rejection of mediation closed off all diplomatic options. Queen Camilla's representatives directed the London law firm to accelerate legal proceedings. The institutional crisis entered a phase of direct confrontation. With administrative mediation, exhausted Prince William as Prince of Wales and sole lawful heir to the Highgrove estate assumed direct command of the institutional defense strategy. Prince William's position was cold, unambiguous, and rooted in absolute principle. He refused to frame the matter as a personal or familial dispute. To him, it represented an unacceptable breach of Crown asset governance. Highgrove Estate and its auxiliary holdings were historical institutional assets protected by statute. They could not serve as private compensation or financial settlements. Prince William immediately formed a special legal task force operating independently of Standard Palace advisors. Comprising top young constitutional and trust lawyers recruited from Oxford and Cambridge, the team offered sharp legal analysis free from traditional court ties and committed strictly to statutory compliance. Concurrently, Lady Louise Windsor, holding a degree in constitutional law and possessing expertise in royal archives, was appointed by Prince William as head of process control and file security. Lady Louise was tasked with auditing every procedural detail to ensure that every royal counterfiling complied meticulously with the civil procedure rules, the Sovereign Grant Act, and Privy Council regulations. During strategy sessions in the Kensington Palace Library, a telling institutional dynamic emerged. Princess Charlotte, though only 10 years old, sat quietly in the corner of the room, observing her father and the legal team. At 10, Charlotte was already developing an acute awareness of the weight of the crown and the uncompromising nature of dynastic rules. She asked no naive questions. She simply studied the thick dossiers, the red boundary markers on cadastral maps, and the tense atmosphere of the room. It was a primary lesson for the next generation. True power lay not in public splendor, but in the unyielding legality of constitutional documents. The strategy devised by Prince William and the Oxford-Cambridge legal team avoided media engagements or personal pressure. Instead, they constructed a procedural trap based strictly on prevailing law. First, they audited the financial records of the design firms owned by Annabelle Elliot, cross-referencing every payment received from the sovereign grant over the preceding 20 years to identify potential conflicts of interest. Second, they reinforced the legal invalidity of the 2018 memorandum by citing the Sovereign Grant Act 1961 and the 1996 Privy Council ruling, demonstrating that King Charles III lacked the legal authority in 2018 to promise the transfer of a trust-protected asset. These findings were compiled into a confidential illegality file. Prince William prepared to present this dossier in a decisive confrontation within the Privy Council chamber, where the matter would be concluded without a single detail leaking to the public. The closed-door meeting was convened on a Tuesday afternoon in the council chamber of the Privy Council at St. James's Palace. No media was present, and no press aides were admitted. The oak-paneled room, centered around a long mahogany table, served as the setting for a legal confrontation vital to the financial order of the monarchy. The petitioning party comprised Queen Camilla Annabelle Elliot, the lead litigation partner from the Chancery Lane firm, and Colin, the family's longtime personal financial advisor. The responding party included Prince William, Prince Edward, Lady Louise Windsor, and 2 constitutional lawyers representing the Special Legal Task Force. The atmosphere in the room was silent and formal. There were no social pleasantries or emotional outbursts. Every action adhered strictly to the administrative procedure managed by Lady Louise Windsor. The lead partner from Chancery Lane opened by presenting a 30-page submission relying on King Charles III's written commitment from 2018 and asserting that withholding absolute title to the Wiltshire parcel infringed upon the Queen Consort's lawful property expectations and standing. When the attorney concluded, Prince William offered no personal reaction. He simply nodded to the Oxford-Cambridge legal team. A legal expert representing Prince William stood and opened a green leather portfolio bearing the seal of the Privy Council. In a measured tone, he began citing statutory precedents. He first introduced an administrative audit report from the National Treasury, revealing that the $350,000 retainer paid to the Chancery Lane firm had been drawn from accounts allocated for official public functions. Utilizing state-funded allowances for private litigation aimed at personal real estate acquisition constituted a major violation of the sovereign grant regulations, an offense that could trigger an immediate independent investigation by the Parliamentary Public Accounts Committee. Next, Prince William's counsel presented the primary evidence, the original 1996 Special Trust Protocol established by Prince Philip, alongside its formal ratification by the Privy Council. Council highlighted Clause 14b, any commitment memorandum or private agreement executed by any member of the royal family attempting to convey, encumber, or alter the legal status of royal trust assets without the written consent of the Board of Trustees and parliamentary approval is legally void ab initio. The legal expert concluded with a concise assessment. The 2018 memorandum relied upon by the petitioning party was entirely devoid of constitutional standing. Should the Queen Consort proceed with the lawsuit in the High Court, the Royal Legal Task Force would immediately submit the full file to the Privy Council and the Ministry of Justice to have the action dismissed as frivolous while requesting a full parliamentary audit into the funding of the legal fees. A heavy silence fell over the chamber. The lead partner representing Queen Camilla, a veteran litigator with decades of London court experience, recognized that his position was legally untenable. His arguments had been systematically dismantled, not through debate, but through the application of constitutional law. Faced with severe professional risk and potential reputational damage from a parliamentary audit, the senior attorney turned to Queen Camilla and Colin. Bowing his head slightly, he announced the immediate termination of his legal representation, committed to returning 50% of the retainer fees received, gathered his files, and promptly exited the chamber. Queen Camilla's legal challenge collapsed in under an hour. The outcome in the Privy Council chamber was not the final action. Prince William moved to implement institutional measures designed to prevent any recurrence of similar actions. It was a financial sanction executed through formal administrative channels. The following morning, exercising administrative authority over royal estates, Prince William signed a blanket contract termination order. Under the Royal Procurement and Services Regulations, all consulting interior design and procurement contracts held over the past 20 years by companies managed by Annabelle Elliot across the royal estate network, including Buckingham Palace, St. James's Palace, and auxiliary properties, were terminated with immediate effect. The official technical justification cited was the restructuring of public tender procedures to comply with updated financial transparency standards under the sovereign grant. This decision removed an annual income stream worth hundreds of thousands of pounds from Annabelle Elliot's firm, sending a clear message any attempt to compromise Crown assets would result in complete severance from the financial network of the royal household. Simultaneously, the official audit regarding the 45-acre Wiltshire parcel was formally finalized in internal records. The document confirmed that the land remained locked in perpetuity as a public asset of the Royal Trust. Queen Camilla retained only a lifetime right of residential occupancy and spatial use. She was barred from selling, mortgaging, transferring, or bequeathing the land in her personal estate. Under the terms of the trust, upon her passing, sole administrative control of the 45-acre Wiltshire parcel will automatically revert to Prince George, second in line to the throne. Consequently, Queen Camilla's children, Tom Parker Bowles and Laura, along with her granddaughter Lola, were permanently excluded from any inheritance property rights or financial claims associated with the royal estate. The prospect of establishing a private real estate holding connected to Crown assets was legally closed. 1 week after the Privy Council meeting, normal administrative routines resumed across the royal palaces. No public statements were issued, and no details regarding the legal dispute appeared in the press. Public communications remained focused on official engagements, charitable visits, and routine appearances. Behind the scenes, however, the balance of administrative authority had shifted. At the Highgrove estate, Prince William stood by his office window, looking out over the grounds he is designated to manage and preserve. Beside him was Prince Edward, who had just completed the final audit summary for deposit in the confidential archives at Windsor Castle. Colin, the financial advisor, and Queen Camilla's private legal team had completely withdrawn. They recognized that against the constitutional framework of the monarchy, private financial resources and political connections were ineffective against established legal protocols. The outcome was finalized without celebration. Prince William, Prince Edward, Princess Catherine, and the core leadership engaged in no public victory. The atmosphere remained professional, quiet, and reserved. Prince William recognized that preserving the institution demanded strict adherence to legal duty. The Crown could not maintain its standing through personal concessions or informal compromises. To ensure the continuity of the monarchy under historical and public scrutiny, administrative vulnerabilities and private claims had to be addressed through legal mechanisms. Princess Charlotte entered the room, carrying her coursework on British constitutional history. The 11-year-old acknowledged her father and Prince Edward with formal protocol before taking her seat at the desk. The continuation of responsibility occurred not through formal speeches, but through observing the practical operations of institutional governance. A firm operational structure was maintained. The assets of the state and the Crown were secured behind established legal boundaries. The administrative system of the British monarchy continued its function, measured quiet and unyielding as it had for centuries. From an institutional governance perspective, was the Prince of Wales's decisive intervention a critical constitutional safeguard to preserve public asset integrity? Or did it demonstrate a legal rigidity that further fractures internal family structures? And will this strict enforcement of trust protocols establish a stable governance foundation for heirs like Prince George, or inadvertently bind the Crown within an overly restrictive control framework for generations to come? In a sea of videos, I am so glad YouTube managed to bring this one to you. We pour a tremendous amount of care into researching every single detail of these royal histories. I know using a TV remote takes a little extra time, but your like and subscription are the ultimate motivation for our team to keep creating careful, high-quality stories for your screen. Thank you so much for your support.